As mentioned here, it's almost impossible to do business today and figure out how to be successful and legal-wise to do business in Russia. And we definitely, without a lawyer, would be very risky to start even thinking about probably going today and start new partnership with any Russian businesses. And for that reason, we have Larry, who is an expert on doing business in Russia. When preparing for this meeting, I look on Larry's resume. This is the the biggest resumes that I ever saw, like 5 pages. I said, wow, it should be a lot of knowledge behind this, those 5 pages. Okay, thank you. It's a lot of work and a lot of knowledge.
Thank you. Good morning, everybody. So as Nikolai had mentioned at the outset, my name is Larry Ward, and I am from Seattle, Washington. Nikolai called it the other Washington. I don't like to refer to it as the other Washington. You can refer to it as the less crazy Washington, perhaps, or the state of Washington. But I'm based in Dorsey's Seattle office, but frequently come back to Minneapolis because many of our clients are based here in the Twin Cities. My background in terms of the Russian sanctions, just to give you a little bit of knowledge of where I'm coming from, my practice area generally deals with U.S. national security law. So it picks up U.S. export controls, picks up economic sanctions, and foreign direct investment into the United States. With regard to Russia specifically, one of our clients that I've worked with for a little over a decade now is a company that has pretty significant operations in the United States and Canada, but just so happens to be owned ultimately by the Russian government. And so several years ago when these Russian sanctions first began, that particular client, which is owned by a Russian government agency with ties to the Russian defense sector, was obviously quite worried about the possibility that the company itself would ultimately become sanctioned under these laws, and where would that effectively leave their U.S. operations and their Canadian operations. So I've literally tracked these sanctions since day one, when President Obama issued the first executive order, and even before that, while the disruption in Crimea was occurring. So I've really followed these and tracked these from the beginning all the way to today, which is a little bit of an uncertain time, as Matt had mentioned. The Congress had acted earlier this year to codify the sanctions that President Obama had put in place, but we're still really uncertain as to exactly where things are going to fall, because as Matt had mentioned, OFAC in particular, which has to go ahead and implement the congressional action, hasn't actually put out new regulations yet, and they haven't put out FAQs, which would help companies figure out exactly where things are headed. So what I'm going to say today in 30, 60 days could be a little bit different, just because OFAC will ultimately say how they are going to implement the congressional action from this summer, and that could certainly change the landscape as to Russia. I think at the outset, it's also important to mention with regard to these Russian sanctions, a lot of you, it looked like about 60% of you are doing business in Russia currently, maybe 40% of you that aren't doing business in Russia, maybe it's because of the sanctions that you're not doing business in Russia, maybe there are other obstacles, but ultimately at the end of the day, at least as of now, for most companies, these sanctions really don't have an impact of stopping trade with Russia. And I think it's really important to just mention that at the outset. Matt mentioned certainly the counter sanctions that Russia has imposed in the agricultural sector, which certainly will impact a lot of Twin Cities companies. But if you're not in the oil and gas sector, and if you're not in the financial services sector, really these sanctions won't have as huge of an impact on your company as they might on other companies. And so I think it's just important to mention that at the outset. Those of you that are doing business in Russia, just by a show of hands, how many of you have had complications with the sanctions? Okay, so a few. And then those of you that are not doing business in Russia currently, how many of you are not doing business in Russia because of fear of the sanctions or because you know that the sanctions are prohibiting you from doing some work? Maybe, again, maybe a few. Okay, so that's good background information for me to have. One other thing that I just want to mention at the outset is that throughout the presentation that I have today, feel free to interrupt with questions. It's going to make it a lot more enjoyable for you and for me. So don't hesitate to ask any questions along the way. I just wanted to give a little bit of background before we dive into the Russian sanctions specifically on the U.S. government agencies that administer sanctions. There's really three branches within the U.S. government that deal with sanctions. OFAC, the Office of Foreign Assets Control, is really the main agency that deals with economic sanctions. It's the main agency when it comes to the Russian sanctions, and so a lot of what I'm going to talk about today is dealing with OFAC. The other two, Matt mentioned BIS within the Commerce Department. The BIS has worked hand in hand with OFAC throughout this whole process since March 2014 on figuring out exactly what items need to be sanctioned and how the BIS needs to work in conjunction with OFAC in these sanctions. And then the last one is a little bit less common, but the DDTC, the Directorate of Defense Trade Controls, regulates the ITAR, which is the International Traffic in Arms Regulations that deals with defense or military exports. So for most companies, that set of regulations is never a concern, and so you don't need to worry about it. But the DDTC does have its own sanctions when it comes to Russia, and effectively, the DDTC sanctions are that any license application of a defense article, trying to export a defense article to Russia is just not going to happen. And so for those of you that do work in the military or defense sector, just realize that it's probably not going to happen. As Matt had mentioned, OFAC has some pretty serious penalties for violations. And so this oftentimes is what scares a lot of companies from violating the sanctions, right? Most of the enforcement actions involving U.S. sanctions fall on the civil side. The civil side is how OFAC deals with sort of the unintentional, in most cases, violations of the sanctions. As Matt had mentioned, there is strict liability. I remember years ago having a meeting with OFAC where our client had absolutely no idea they were violating the sanctions laws. The folks from OFAC, you could see across the table just that human nature where they legitimately felt sorry for our client, that they didn't know that these sanctions were in place and affected them in the way that they did. At the end of the day, they didn't really care. And so that's really how OFAC sort of handles these things, is that it truly is strict liability. And so if you've made an accident, that's fine, but they still need to go ahead and enforce the law. Most all of the enforcement actions that OFAC deals with, though, at the end of the day, if you disclose it to OFAC voluntarily, most actions that OFAC deals with are dealt with by a cautionary letter. So it's basically a letter that says, you've done something wrong, don't do it again, change your compliance procedures to fix it, we're not going to penalize you this time around. However, OFAC has probably somewhere between 10 and 20 enforcement actions each year that do have penalties to them. And the penalties tend to be pretty high, from $1 million up to $1 billion in a case within the last couple of years. So the penalties can be quite staggering. I've put up there what the per transaction penalty can be, but it can also be 2 times the transaction value. So if you sell something worth $10 million to an entity that you're not supposed to sell it to, your penalty could be $20 million. So the penalties really can get quite high. On the criminal side of things, the Department of Justice is the agency that actually deals with any criminal violations of these laws. OFAC just turns it over to DOJ to deal with. For those of you that are in this room, if you're in this room, there's, I would say, almost a 0% chance of you ever facing criminal penalties, right? Because you're trying to figure out how not to violate these laws. And the criminal penalties typically deal with people that want to actually sell components to nuclear weapons to Iran and other places that we don't want them to go to. So I don't think that's most of the crowd here. The legal authority behind the sanctions I'm not really going to delve into too much. I do just want to mention in terms of the Russian sanctions, how these have really been dealt with up until this summer has been by executive order. So President Obama basically signed a series of executive orders, as Matt had shown you, that basically outlined exactly what the sanctions were going to be. And the OFAC regulations themselves dealing with Russia and Ukraine sanctions basically were just those executive orders. Executive orders can be put into place by the president at any time. A president can go ahead and dissolve an executive order. His successor can go ahead and dissolve an executive order. And so that was the major concern this past summer, and we'll look at that in a few slides. In terms of sanctions, OFAC has different sanctions regimes. They have total embargoes on particular countries, and then they have more refined sanctions that target particular individuals, entities in a particular country or in a particular region that are believed to be unstabilizing in some way. When you're dealing with OFAC sanctions, they deal with all U.S. origin goods. They deal with all financial transactions involving the United States. And they don't take into account any sort of strategic or military importance of the items that are going to the sanctioned individual or entity. Right now, OFAC has a series of total embargoes on Cuba, Iran, North Korea, Sudan, and Syria, and the region of Crimea. The United States does not consider Crimea to be its own country, although the Russians do. We consider it to be a region, and it's still referred to as the region of Crimea. These comprehensive sanctions programs are effectively total embargoes, so that these countries are effectively off limits to U.S. persons. There are some license exceptions and some exemptions within the laws. So, for example, if you're a medical device company, which I suspect there are some of you in this crowd that are, medical devices, medicines, agricultural commodities, those sorts of things oftentimes fall within a license, so you can go ahead and export them to those particular countries. The United States, at the end of the day, they realize that although they're trying to, through these sanctions programs, to effectively get at the ruling regime within a country, at the end of the day, particularly within the case of Iran, the impact is ultimately felt most by the ordinary citizens within those countries. And so in order to alleviate some of those concerns, the U.S. government has implemented these general licenses to allow certain activities with these countries. And then there's a whole host of other countries where, as I'd mentioned, certain individuals, entities are targeted within the country. And so I've just listed those out there. Aside from those sanctions programs that deal with particular countries, OFAC also has specialized programs that deal with certain activities that are obviously harmful and destabilizing. OFAC maintains several lists of entities that are sanctioned. I've listed them up here. The SDN list and the SSI list that Matt referred to are particularly important when it comes to Russia. There's also a foreign sanctions evaders list and a Part 561 list, which are more important when you're dealing with Iran. BIS and DDTC, the other two agencies that deal with economic sanctions, also have their own separate lists. So it's important to check all of these lists if you're doing business in one of those countries that I've listed out on the previous slides. OFAC has its own website, its own portal to check these various lists. As Matt had mentioned, there is also a consolidated list that puts together the OFAC list, the BIS list, and the DDTC list, as well as some others that are maintained by the State Department. And so it's best to check that particular list. I've put the OFAC one up here just because that's sort of where it falls in this series of slides. A couple of things that are really important just to mention on this list checking. How many of you are at companies or have clients that check these lists through some sort of commercial software program? Okay. And how many of you use manual checking? So meaning you just, when you have a particular transaction or order, you go to these U.S. government websites and you just enter them yourselves. Okay, so So a couple of words of caution for both groups. So with respect to manual checking, if you don't have a huge international operation, you don't have a lot of international sales, that manual checking can often make sense because it saves you money to go ahead and save on that annual licensing fee from a commercial software company. With manual checking, the only thing you need to be careful about is you need to make sure that you're entering the names correctly into these US government websites, because they aren't always going to spit back at you the result that you're looking for. So if you put in a typo, you might get an incorrect result. The other thing with the manual checking is that oftentimes you get that initial interest from a customer, you check the list, 60, 90 days go by, you don't check the list again when you actually go ahead and ship the order. These lists change all the time, and so it's important that if you're doing the manual list checking, it's really important to go ahead and make sure that when you actually go ahead and export, you check the list as well. So you may need to check it 2-3 times throughout the process. For those of you using the commercial software programs, those are very good. They not only give you the result when you enter it, oftentimes they will, if you put in a typo, they're going to go ahead and look at sounds like and things like that. So they're going to give you a list of results that, that may be very useful. In addition, those commercial software programs tend to give you an alert when a prior customer or a prior entity that you entered appears on one of the lists. And so again, if you have that 60 to 90-day lag time, that can be very useful, because if an entity comes up on the list, it gives you that alert, and so you know to stop the order. As I'd mentioned earlier, OFAC has a series of exemptions. It also has licenses, so even if something is not allowed under the laws, you may be able to apply to OFAC for a license to be able to do something. If your activity isn't sort of humanitarian in nature, the likelihood of you getting a license from the US government is pretty low. So if you're just looking to sell commercial goods into one of these countries, it's probably not going to happen. But if you have something that can really benefit the people of a country in terms of safety, in terms of life, those sorts of things tend to get approved by OFAC. And then I've put up on these next 2 slides just some tables that sort of allow you to look at what exactly the US allows and doesn't allow as to the countries that are totally sanctioned. Some of you may have heard in the last couple of weeks that North Korea is now prohibited by travel. That's not under the OFAC sanctions, so that's why there's not a check mark in that box. That's actually through the State Department that those visa restrictions are in place. So moving now to the sanctions with respect to Russia. As Matt had mentioned earlier, there is a range of sanctions when it comes to Russia. So not only do they target specific individuals and entities, there's also a comprehensive ban as to the region of Crimea. The sanctions really target particular Russian officials, individuals, families, companies, banks, and industry sectors. And I think this is really the most, probably one of the most important bullet points within this whole deck. When you look at sanctions programs dealing with Cuba, Iran, North Korea, Sudan, and Syria, those nations tend not to have companies, tend not to have individuals that are particularly savvy when it comes to international trade. And so they really haven't dealt well with the sanctions or avoiding or evading the sanctions. When it comes to Russia, on the other hand, Russia is a country that has, within the last 20 years or so, really exploded on the international trade. Those companies, those individuals really know the ins and outs of international trade. As a result, they know how to avoid the US sanctions. And that's been one of the largest compliance problems for US companies, is that many of these individuals, many of these companies that are targeted have played a shell game. So if the individual owns a company, he'll go ahead and sell it to his son or sell it to his wife or sell it to an uncle that isn't sanctioned. And so it's become very difficult for US companies to figure out just who they're dealing with and whether or not they have ties to these particular individuals and companies that are sanctioned. And so it's really important for you to do that due diligence and figure out just who you're dealing with. I had a client last week that was dealing with a company that was safe ultimately, but it had the same name as another entity that was sanctioned. And it looks like, at least from the research I was able to do, is that other entity had gone ahead and tweaked its name to avoid the sanctions. And so it's something that really comes up for a lot of clients, and as a result has caused many companies just not to do some business in Russia because they want to avoid the diligence problem. These Russian sanctions have largely been implemented by OFAC through 4 directives that basically indicate the business that you cannot do with particular Russian individuals and industry sectors. And so I've listed out the 4 directives up here. Really, again, they target the financial services, energy, defense, and oil and gas. And so if you're not within one of those sectors, again, the likelihood of you being able to do business in Russia is much greater. With that said, over the summer, the Congress did go ahead and implement new sanctions as to Russia, and OFAC is currently dealing with those. So what I suspect to see is that there will be more directives that come out with respect to Russia within the next few months. The OFAC guidance on Russia really has dealt with that problem of the shell game by implementing this 50% rule that they call it. And it's effectively if a Russian individual or entity owns 50% or more of another company, that company that is the subsidiary or affiliate entity is also considered sanctioned. And so again, this is a big diligence problem. You really have to track who owns the company that you're dealing with. And so when it comes to Russia, you really do need to go ahead and delve into diligence more so than you might in many other countries. Yes?
I have a question on the previous slide. When this offers came up a couple of years ago, I had heard a term called a shadow SDN, which I understood to be basically if you've got somebody who becomes blocked by first application of the 50% rule, and then you look at who that 50% blocked person then owns. The question at the time was, would the 50% rule drill down to subsequent levels? Have you heard anything on that?
It does. I mean, you still have to keep tracking, what the ownership level is, and so if it's diluted enough, meaning if that entity at the bottom of the pyramid is only ultimately owned 2% by the sanctioned individual or entity, then that entity at the bottom would not be considered sanctioned. I think both OFAC and BIS would indicate that you probably still need to deal with that entity very carefully, and if there are any red flags that suggest that 2% is really more like 50%, you need to deal with them accordingly and deal with them cautiously. But that's sort of how OFAC tracks it. But if that 50% tracks all the way down to the bottom, that entity at the bottom is also considered sanctioned. That's a good question, though, and it really highlights the difficulty that companies have, because oftentimes these Russian companies will have many layers to them, and so that company at the end of the road, you have to look at who ultimately owns it. On the BIS side, the BIS has its own sanctions that tie in very closely to the OFAC sanctions and sort of limit the types of technology that can now go to Russia. Really, the impact of these sanctions was intended to get at the Arctic offshore drilling, and so that's ultimately the items that are targeted under the BIS's program really are those that would impact the oil and gas sector in the Arctic region. BIS has also listed out a host of what are referred to as ECCNs. So those are numbers within the BIS's commerce control list that indicate certain technologies that are controlled. And so there's a list of items that cannot go to Russia that track both within the oil and gas sector, but in some other sectors as well. So if you know you have items controlled on the CCL, it's important to check and figure out whether your items can go to Russia. And as I'd mentioned earlier, defense exports are basically off limits when it comes to Russia. So politics, that's really where we're at now with the Russian sanctions, and I'm not going to get political here, but I do want to just highlight this tweet because this is really what has set off within Congress the recent act that was approved by both houses of Congress overwhelmingly. Back in December, before he actually took office, then President-elect Trump tweeted this particular tweet, and behind the scenes within the U.S. Senate, particularly with the individual that's in charge of the U.S. Senate, this tweet did not go over very well. And so as a result, that particular individual in charge of Congress got together with a group of other senators and indicated that he needed those other senators to go ahead and do something about Russia in particular, because he was very concerned about the president removing everything that President Obama had done with respect to Russia. And so as a result, the Congress has, over the summer, implemented a new act that implements all of President Obama's executive orders and requires that there be congressional action before those sanctions can be lifted. And so that's where we're at today. The new sanctions that have been put in place over the summer, again, really don't impact a whole new host of entities or industry sectors yet. But within the coming months, they might. And so it's really important over the next 30, 60, 90 days to visit the OFAC website. If you don't already get alerts from OFAC, you might want to go ahead and do that. We also do regular e-updates to clients, and so if you'd like to get on those lists, Jane Wilgus, who's in the back, can certainly put you on those lists. But there are going to be changes when it comes to Russia within the next 3 months or so.
Doing our due diligence, and we're still in process. But we've also been asked if the equipment, instead of being delivered as whole, could be delivered as components for final assembly in Russia. Does that change any way the requirements on our company for sales?
I don't think it would necessarily, but it could. So what I think you would really need to look at is those components. So is that final assembly really going to occur, I think is what you need to look at. And so if the components that you have could be used in some other areas, particularly the oil and gas sector, that's probably a big red flag. So if those items can be used, for example, in the Arctic offshore drilling, in other sectors within Russia that are already targeted, then I think you probably need to be a little bit more concerned and need to think it through as to whether or not it makes sense to go ahead and do that. I wouldn't say that necessarily any of the U.S. government agencies would go ahead and penalize you for making those transactions or sales if you didn't have sort of proof that those components were going to be used in those sectors. But I think if you have red flags, it's a red flag enough to at least go to the U.S. government and ask. Which brings me to another point that I wanted to mention. When it comes to dealing with BIS and OFAC, BIS is great about helping companies answer questions. I would be cautious of what you tell BIS, because at the end of the day, the Office of Export Enforcement sits within BIS, and so if you've violated the law, you want to be careful. But BIS is really good about helping you figure out diligence items, so specifically like that. They're really good at helping you figure out, okay, are these components that really could be used in the oil and gas sector? And so asking them those sorts of questions can be very useful, and they really do try to work with you to help you along the way, because at the end of the day, commerce is trying to affect trade, and they're trying to help U.S. companies trade with other countries. So BIS is very good in that regard. OFAC, on the other hand, is not. OFAC, you can ask a question to OFAC, and it can take literally years for them to get back to you on. OFAC also comes at everything with immediate distrust. And so I'd kind of avoid OFAC unless you have your lawyer asking OFAC the questions. That's just my 2 cents.
From an OFAC perspective, can you describe the applicability of the regulations or the requirements on wholly owned foreign subsidiaries of U.S. entities?
That's a great question, and one that I suspect is going to have some changes in the coming months. So as of right now, I'm not going to flip back because it's going to be tough to find the slide. But as of right now, there are only 2 sets of sanctions that impact foreign subsidiaries of U.S. companies, and that's the Cuban sanctions and the Iranian sanctions. And so the Russian sanctions, Ukraine sanctions, a foreign subsidiary of a U.S. company can go ahead and do business with Russia. A U.S. company or U.S. persons involved with that foreign subsidiary cannot assist with any transaction that would be sanctioned. So you basically have to set up that dividing wall. If the foreign subsidiary can do something with Russia, great, go ahead and let the foreign subsidiary do it, but there can be no U.S. involvement, there can be no U.S. origin goods.
After the fact, wouldn't rise to that level of involvement? For instance, from a financial reporting perspective, seeing the impact of transactions.
That's all. So if it's sort of administrative in nature, financial reporting, U.S. companies can certainly get that. If something flows to the board in the U.S. naturally, you certainly can get information about all that. It's the approvals of the transaction. So if the U.S. company actually has to approve the transaction, that's where you could get into what's called facilitation, and that could be problematic. So you kind of just have to set up that dividing wall, let the foreign subsidiary deal with it. The sanctions on Iran, although they do pick up foreign subsidiaries right now, there's a general license in place that does allow foreign subs to do business with Iran. I expect that to change in the coming weeks. And with respect to Russia, that's something that I think is just something you need to watch in the coming weeks, because as OFAC implements the new congressional action, that could change, and so foreign subs could be picked up. We just have to kind of wait and see. Yes?
Larry, if I might just make a footnote to that, bear in mind that where do a lot of American companies serve the Russian market? They serve it from subsidiaries of the European Union.
Yeah.
There's a fair amount of overlap between the U.S. and the EU sanctions. It's not complete, so having the EU subsidiary do some things is not necessarily going to put you complete.
Yeah, that's absolutely right. Yeah, I mean the EU has actually been a little bit more aggressive, I would say, at the end of the day when it comes to sanctions on Russia. And so as a result, EU subs are not going to be able to do something with Russia that a U.S. company couldn't in most instances. Where I think there's going to be a big divergence in the coming months is with regard to the energy export pipelines, particularly the Nord Stream pipeline. Right now, EU companies can do work on those. These new sanctions restrict or it could implement sanctions on that sort of work. And so I think that could be a dividing line between the EU and the U.S. In the coming months.
My apologies about the question. We need to follow this schedule because we have another event coming after this one. Okay, and maybe you can in 5 minutes to finish.
Yeah, no, I'm actually going to wrap up this last section in terms of compliance tips. I've really sort of talked about this throughout. Just the risk assessment that you need to do, the controls you need to have in place, the steps you need to be taking when dealing with Russia. So I'm not going to go into any of these slides in great detail. One thing I do want to mention on this risk assessment is this second bullet point here about understanding the business units and individuals that are subject to sanctions. ExxonMobil was just recently slapped by OFAC with an enforcement action because they had signed an agreement that was also signed by a Russian counterparty who individually was sanctioned under this act. The company was not. And so Exxon is actually fighting that in the courts now. But it's really important to understand that you really do need to look at who are all of the individuals that are involved with the companies that you're dealing with in Russia, just to avoid sort of that fate of ExxonMobil. Internal controls are obviously important, and we've talked about that throughout. Training your individuals that are making sales with Russia is hugely important, allowing them to understand what the red flags are. And OFAC and BIS both have resources OFAC has a series of FAQs, which is what I'd really watch in the coming months as they implement their regulations. Usually the regulations get implemented and then companies come to them with questions, and then ultimately they go ahead and put FAQs up on their website, so it's something important to watch. And then making sure that you go ahead and are regularly auditing your sales to Russia is something that's important. And so with that, I'm going to go ahead and wrap up. I will be here throughout the day and certainly during the break to take any more questions that you guys might have.
Thank you very much.